Let's take you to this now. Members of the Ad Hoc Committee investigating allegations of criminal infiltration, corruption and political interference in the justice system had to defend the inquiry after businessman and alleged criminal cartel kingpin Mpumelelo refused to disclose certain information in the testimony. The Ad Hoc Committee is sitting at the Mpumelelo Correctional Services facility in Gauteng. Mpumelelo refused to speak about issues that may incriminate him after the investigation. Chairperson of the committee, Soviet Likhanyane, had to intervene. Legal analyst Mpumelelo Zikalala joins us now to talk about the privileges, if any, that are afforded when one testifies in such inquiries. Do those privileges have limitations, and if so, can they be exploited? Mpumelelo, good evening. Thank you so much for your time. Really do appreciate it. Let's start here. The rationale here is that whatever you tell us before Parliament can't be used against you in a court of law. If Parliament comes, if those who are investigating you and prosecuting you come to a similar conclusion, they must have come to that conclusion through other means other than relying on what you said in Parliament. Now that seems like a very thin line on the protection against self-incrimination. Why is the protection against self-incrimination so important for Parliament to be able to do its work? But secondly and importantly, what are the limits of that protection from self-incrimination?
Good evening to you and also to your viewers. Well, let's remember that you have a constitution in our country that says that you're not going to self-incriminate yourself. It's one of the rights which are afforded to you. But the trigger for that right is that you must be dragged in a court of law, and most of the time it's going to be criminal proceedings. Now, in a case where it's Parliament, there are no criminal proceedings which are against you, but you know that whatever that you state will be used as a lead to any other investigation which is taking place. Then it's upon you to state, I'm going to answer that, I'm not going to answer that. You may be forced and coerced, as it has been done now within the Parliamentary Committee, but at the end of the day, you have every right to say, because there's going to be another forum which is going to discuss this matter, I'm not going to discuss it. I can only give you a limited number of information which is already available out there, but I'm not going to disclose my defense, sort of to give the state a head start in terms of how we are going to defend this matter. It may sound a bit bad in certain other individuals, but at the end of the day, you can't be forced to disclose whatever information that you don't want to disclose. And at least in this case, Mr. Mpumelelo has said, I'm going to participate up until a certain extent, but when it gets to something in which it's a matter already in court, I'm not going to disclose that. But
can I pause you there? Can I pause you there? Because Mpumelo's participation right now is a voluntary participation. He was invited. He wasn't forced to be there. But Parliament and the committee could otherwise choose to force him to be there through the issuance of a subpoena to summon him to appear before him. Would that make a difference on whether or not he can choose to speak about certain things or not?
Not at all, because at the end of the day, whether you're invited or you've been summoned, once you are in there, the procedure is more or less the same. You are sworn in, provide information, and we are going to probe you as it will be done tomorrow. So if there's any information that you are not going to answer, it either works the work of the committee, for lack of a better word, useless, because you're not going to get any information, or it makes it useful if you are going to provide information up to a certain extent. Which is why, by the way, I think if you look at all the individuals that have appeared, legal practitioners are sitting at the back, sort of providing advice to say, yes, you can answer this, don't answer this one. It may land into trouble as we are moving along. And the rationale is going to be, I want to disclose all in a forum which is going to matter the most. Parliament will not send me to jail, but the court will. So if certain information is going to assist the NPA in creating a perfect case for themselves, I do not want to give them a head start. I want to deal with them in court and be able to deal and answer where in a forum in which has got much more dire consequences than Parliament.
Yeah. And if it does decide to spill the beans, so to speak, that is to say to unreservedly and unfetteredly tell us everything, the NPA couldn't actually use that in their evidence before a court of law, unless, of course, they come to the same conclusions through their own investigations. What is the legal precedence around the interest of justice when it comes to that, the admissibility of evidence before before court that was obtained through a portfolio committee and or a commission of inquiry?
Now, strictly speaking, you may say that there's that immunity which would apply, but on a practical basis it does not exist. Reason being, It's very rare where an investigating officer will go to court and say, let me explain to you how I came about with this information. Most of the time, it's going to be information which has been obtained. You'll find it through an affidavit. You'll find it through transactions which are going to take place. Let me make an example of what's happening today. So a person said, I paid a certain individual 300,000 and 200,000. It may be that I've only discovered that now, but it's going to probe me now to go and check the bank statements and to see, oh, here's the flow of money that goes in here. And when I go to court, I'm going to say, as part of the investigation in the timeline which we're still going to do, checking the banking details was something which was going to be relevant. Why? You have a person who is a member of the public, you have a person who was within the Ministry of Police and may exert some type of pressure or undue influence on the powers that be when it comes to procurement matters. So I was simply doing my investigation. Even if I hadn't heard the testament of Mr. Matlala, I would have still conducted that. That's why it's a bit difficult if you want to challenge that admissibility of evidence, because you don't know how it came about.
Yeah. Let's just take a quick step back and focus once again on the enforceability of parliamentary notices and or summons, but on a different matter here that I'm interested in. And that is on the appearance of Collins Litwala before the Standing Committee on Public Accounts, SCOPA. He has now defied summons or at least notices to appear at least twice now from the Standing Committee. Is the defiance of a parliamentary subpoena tantamount to contempt in the same way it would be before a court of law?
It's similar to that, but using a different legislation. But now we must have a step back and say, let's check whether the summons were authentic or not. Let's check the address. Let's check whether there was knowledge communicated to the person who was supposed to receive the summons. So if you send the summons to a wrong address, to a wrong individual, and the person that is of interest does not know about the summons at all, it cannot say that they willfully defaulted and did not attend to whatever instructions they received from Parliament. So that's going to be the test to say, have I broken the law or not?
What is the general practice?
It must be, there must be some type of return of service which is going to come back to Parliament, and personal service. Remember, you want Zikalala to come to court or to come to Parliament, so make sure that you're able to serve Zikalala. Either you're going to do so by saying, let me try and find you physically so that I give you those summons and someone is able to sign, and they'll take a report back to Parliament to say, on the 25th of November, I met him at this date at this time, and this message was communicated to him. Here's a copy of it. I then sent a reminder closer to the time in terms of the email that he had given me, and even gave him a call. If you don't have all those things, then unfortunately you can't be able to prosecute, because the defense will be, I did not receive this information. It was sent to the wrong individual or the wrong address.
Yeah. If I emailed your attorney of record, is that sufficient?
If I place my attorneys of record as where I'm going to receive any further communications from you, then the answer would be yes. But remember, there's still a defense on that one to say, at least put the attorney of record under the bus and say to them, they did not pass on the message to me. There was no way in which I could have known that you want me to go to Parliament on that day. But it would be a bit difficult in this instance. The person has appeared in Parliament before. Probably there is a contact number somewhere, somehow, which it could be obtained. There are various ways of communication, and even WhatsApp messages are found to be competent ways of communicating. So to say that you did not receive any information or did not have any knowledge that you are required in Parliament on that day is indeed something that might be difficult to prove. But at the same time, it doesn't absolve Parliament from complying with legislation and making sure that all the processes have been covered in its full extent, so that you are able to punish the individual if they default.
Yeah. Mpumelelo Zikalala, thank you so much for your time. Really do appreciate your insights on this.